Hello, this is Dr. Hawker, and welcome to our very first lecture of our course in American Civil Liberties. This lecture is about civil rights and liberties, Loving and Schenck. So if you haven't read those two cases yet, please go back and do so, and then you can get started with the lecture. I'd also like to say a few words about what these lectures will be like throughout the course. So I try and give you a lecture experience that's as much like the classroom as I possibly can. And that means that if I make mistakes or I get tongue-tied or something like that, I'll just go back and fix those mistakes. I won't start the lecture over and give you something that's pristine. I make those kind of mistakes in the classroom, and so you'll hear them throughout the course. Okay, so let's get started with this lecture. What I want to accomplish here is I want to define what the difference is between civil rights and civil liberties. And I want to do that in a legal sense so that we have an understanding of what sorts of things we're talking about. The course really is divided between subjects that are on civil rights and subjects that are on civil liberties, and it's good to keep this in your mind. So, civil liberties are rights to be free from governmental regulation and or interference. So these are primarily things that we associate with individual rights, and your right to govern the sphere of your life without governmental regulation or interference in it. So you could have a civil liberty from slavery or from forced labor, from interference with your private life. Another example, the one that we're going to discuss today, is the right to be free from governmental regulation or interference in the exercise of your free speech right. Okay, so civil liberties then are things that apply to individuals. So what's a civil right? A civil right is a right to be free from arbitrary governmental regulation that treats you differently than similarly situated persons, other people who are just the same as you. And a lot of times this has to do with regulation of you as a member of a group. So it isn't so much that you are being regulated in terms of a right that you have as an individual, but if government is classifying you as a member of a group and then regulating you inappropriately, we say that government is violating your civil rights. So where government provides a service or regulates an activity, it has to do so non-arbitrarily, and that's really the concept that's at the core of civil rights, non-arbitrary governmental regulation. Excuse me. So let's just get a sense then of what the difference is here. All right, so if government has said that communists cannot speak, really what government is saying there, the question then would be, is government interfering with a liberty or with a right? Okay, so anyone can speak communist talk, really. I mean, generally, communists aren't considered a member of a particular class. You know, we can't look at a group and say, oh, that person's a communist. I mean, you might say, oh, well, a lot of them were Russians. Well, sure, but a lot of the Russians weren't communists, so we can't really make that kind of classification. When government says that no one can speak communist speech, it's regulating, you guessed it, a civil liberty. So it's regulating a thing that has to do with an individual right, a right that attaches to the individual. Okay, but what if government classifies you and says because you are African American, you may not receive this particular good or service? Or if government says, here's maybe a better example. If government says you are male and under the age of 25, you are going to pay more for your car insurance than a similarly situated person who is female and also under the age of 25. Now, is that inappropriate regulation? That would be a question, and that's been brought to courts before. So in the case of charging males under a certain age more for their car insurance than they do for females, courts have upheld those sorts of regulations as being non-arbitrary. Now, why would that be? They are classifying you, and government is treating you differently than similarly situated persons. Well, government does that all the time. It has to have, though, a good reason for doing so. One related to social order, one related to health, safety, and welfare of its citizens. And in the case we're talking about here, it has one. Males under the age of 25 are more likely to drink and drive and to be involved in traffic accidents involving driver error than females under the age of 25, and that was enough to allow courts to uphold those sorts of regulations and classifications as being constitutional. But the point is that in that case, government is regulating you in terms of a right. We usually connect, and this is very important, we usually connect civil rights with something called equal protection of the law. And we associate civil liberties with the concept of due process. Okay, so let's take a look at two cases. The first one is Schenck versus United States. This is a purely due process issue. There is no inappropriate classification or mistreatment of Schenck because he falls into a class of persons. So this is a civil liberties case. It addresses a right to be free from governmental regulation in the exercise of an individual right. Now, Holmes' opinion in this case is interesting because you would think that he would rule in favor of the speech, but he doesn't. He says rights are never completely free from regulation, even fundamental ones like speech. So how do we know when government may regulate speech and when it may not? Holmes goes on to say that government may regulate speech where it is responding to a real danger that threatens its existence or hampers its objectives. So how do we know, though, when a danger is real or when a danger is threatening the existence of a regime or hampering its objectives? Well, he uses a rule that's up at the top there, a rule called the clear and present danger doctrine. He says that a danger must be, from speech, a danger must be clear, so it must be understandable, and it must be present. In other words, it must be likely to occur, proximal. It's not something that government is just sort of forecasting into the future, or it's a remote possibility that that the speech would hamper governmental objectives. The danger posed by speech has to be both clear and present. And he says that in Schenck's case, it was. It was clear. Schenck was advocating lawlessness, and it was present. He didn't just announce it to the world. He targeted his audience to people who were eligible for the draft, and only those people, and he mailed them flyers urging them to resist the draft. So Justice Holmes and the Supreme Court upholds Schenck's conviction. Okay, but Holmes had some other ideas about when to protect speech, and this is from an unpublished dissenting opinion in a case called Balzer. Holmes doesn't publish this dissent, he withdraws it, but we found it in his papers. And he says, real obstructions of the law, giving real aid and comfort to the enemy, I should have been glad to see punished more summarily and severely than they sometimes were. But I think that our intention to put out all our powers in aid of success in war should not hurry us into intolerance of opinions and speech that could not be imagined to do harm, although opposed to our own. It is better for those who have unquestioned and almost unlimited power in their hands to err on the side of freedom. That's really a very good summary of the clear and present danger doctrine. If it's clear and present, then punish those people. But if it's just someone expressing an opinion which is different than our own, we should err on the side of freedom. Okay, our next case is Loving versus Virginia. In this case, actually, it doesn't fall squarely on the civil rights side. Now, Schenck versus United States clearly was a civil liberties case. This one contains both a civil liberties and a civil rights claim. It's both an equal protection and a due process case. So the equal protection, as we said, involves a civil rights claim, and the due process claim involves a civil liberties interest. So what were those interests in Loving? Well, so here's what the court says in its equal protection analysis. First of all, it states the issue. Then it provides a summary of the argument below and of the counsel for Virginia. Now, the counsel of Virginia had argued, and the Supreme Court of the state of Virginia had accepted, that as long as blacks and whites were both punished for entering into marriages together, then it was okay. That so long as everyone's rights were violated, so to speak, it was all right. And this wasn't a racial policy, keeping whites and blacks from marrying. Wasn't a racial policy because both races were punished. The court rejects that equal application theory, and it says that clearly the intent of this policy was racial and only racial. It goes on to discuss a prior precedent in Pace v. Alabama. You might want to look at that. But the court says that we're not going to accept this. First of all, it is racial, an attempt to keep the races apart. And secondly, it's not an attempt to keep all the races apart, but only to keep whites from intermarrying with other races. So the classification is there. That's the equal protection analysis. And then the court states the doctrine that it will use, or the rule that it will apply, which is strict scrutiny. Anytime the state classifies according to race, to harm a race, to put people into a bad position relative to other races, then the court's going to apply something called strict scrutiny. Strict scrutiny means that the court will give that policy the strictest of scrutinies. It will presume that it is unconstitutional, and the government, or in this case the state of Virginia, has to prove otherwise. And then it says that in the application of strict scrutiny to the statute fails. Okay, but that's not all. The Supreme Court goes on to analyze this situation in terms of due process. And it doesn't simply say that blacks and whites have been classified inappropriately in terms of marriage, right? In the same way that, say, maybe a male would be classified differently from a female in terms of purchasing life insurance, in terms of purchasing car insurance. You don't have a fundamental right to drive a car or to purchase auto insurance, but the court says here you do have a fundamental right to marriage. It describes this right as fundamental. And since government is regulating that most fundamental of rights, that triggers the strictest due process analysis. The state has to have a compelling interest to interfere in one's marriage rights, and racial classifications, according to the court, are not compelling state interests. So that is our lecture on civil liberties and civil rights. The intent here was to define those two and to give us two examples of situations in which the Supreme Court has looked at government regulation in terms of equal protection and due process. And the most important thing to pull from this lecture is that equal protection is civil rights. It's a civil rights claim. And civil liberties, it's a due process claim. Civil rights, equal protection, civil liberties, due process. Thanks very much for listening, and we will move along.